Next, from Springfield, we talk with attorney James Lestikow, an estate planner, and learn why everyone should plan ahead for the time when they'll die. Some 70% of Illinoisans die without any estate planning, which can cost their heirs both money and an undue burden in dealing with the many details following a person's death. This runs about 40 minutes.
Jim Lestikow with the law firm here of Hinshaw Culberson. Thanks for joining us on the Illinois channel.
Glad to be here.
You are, I would say, an estate planner, and one of the things as we started this year, everyone was focusing on what the federal government was doing and all the different laws and whether we're going to have new taxes or not. So there was, on one hand, quite a lot of changes. We thought it'd be good to catch up with you on and get your thoughts. And then also just to cover some of the basics, and maybe we can start there first, relative to estate planning and people not preparing for their ultimate demise and not having any kind of a will or any paperwork prepared. Let's go over again the basics. What happens if someone, when they die, have not done any pre-planning for that death from a legal standpoint?
Yeah, it happens all too often, but basically the state of Illinois, assuming we're talking mostly to Illinois people, so we'll concentrate on Illinois law, has a will for you if you don't have one. You may not like it as much as one that you would have done yourself. One of the things that some people find very onerous, if they have a spouse and children, the Illinois says that the spouse gets half of the estate and the children get half of the estate. And especially when they're minor children, there's all kinds of custodial problems. But then at age 18, they become entitled to their property, unfettered by any management, any trusts, any control, and to do with as they please. Another kind of an irksome thing, but it can be somewhat expensive, is that in a will we can waive a surety on a mandatory bond for the person administering the estate. When it's a will, we call them an executor. When it's a no will and the court has appointed them, they are called an administrator. But in any event, they have to provide a bond, performance bond, basically, to the state of Illinois for the way we figure it is twice the amount of the personal estate, everything except real estate. So,
so if someone had a $100,000 estate, you'd have to have a bond for $200,000.
Yeah. And that's if there are individual sureties, that you can find someone who is willing to sign this bond as a guarantor.
Make sure they're not going to run off with the money.
Right, exactly.
Is that a professional person like a lawyer, or is that someone like who's an uncle or a brother-in-law? Or
usually it's going to be a relative, a friend, but they have to have a net worth that's sufficient
to guarantee the bond? Or
exactly. So when
it's like an insurance policy. I mean, if people I think get confused about
yes.
terms like, but we're using bond in a different phraseology than we would if we're talking about a government bond.
Yeah,
or
it's a surety bond. It's not a, it doesn't pay any interest, but they would technically have to disclose this on a financial statement.
Well, let me just say, so the point is, if you die without a will or anything, how much of your estate does a certain portion automatically go to the government?
No, the thing we settled pretty well at the 11th hour for the fiscal cliff going into 2013 was that for well over 94% of the people in this country, there will never be anything, any penny go to the government, any government, when you die.
Because the estate taxes don't kick in now until what, $5 million?
The federal is a $5 million per person, $10 million for a married couple if you do the right kind of planning. And I'll tell you a little bit about, you can maybe even not do any planning and still get away with a $10 million transfer to the next generation without any estate tax. Illinois residents, not quite so lucky. We have an Illinois estate tax separate from the federal, and it has a $4 million level. So for estate planning for the larger estates, we have to start thinking about tax planning again when their joint estate approaches $4 million.
Now, can I interrupt? That's estate planning, but
right.
Some people might say, well, if that's the case, I don't have to worry about a will. And I wanted to delve more into that. Why should anyone then have a will?
Well, a will, besides the two things I mentioned with regard to controlling who gets your property and who is going to administer it, you can designate the person that you want to be the executor. If you don't have a will, it's going to be the spouse, if you have one, or a child, or a brother, or a sister, or a parent, and the priority is laid out in the Probate Act, where this guidance comes from. And so the best person to do it might be your cousin John, but he can't do it as long as one of those other people ahead of line want to do it.
And it's possible in this day and age, I mean, we talk about this new family life that we have. It could be that this is your second wife, and she doesn't like your kids.
Exactly.
Which could be problematic, obviously.
Yeah, or the first child in line, you have no spouse. The first child in line is estranged from the family and has a grudge, is disabled, but not so much that they are going to be unable to qualify to be an administrator, or have personal issues, addictions, whatever. And if they say they want to do it, they can do it. So you can tell where you want the estate to go, who you want to have it. You can impose trusts on it. If you don't want people to have your estate when you die, no matter what age they are,
you can carve someone out and say you don't get anything.
You can. Well, number one, yeah. I mean, there's a lot of things. If there's someone you don't want to have any of it, you can carve them out. Two, you can impose trusts for minor children. You can impose a trust for someone who has a disability, who is receiving benefits from Social Security or from Medicaid, and you can, Medicare, you can carve them out, put their money into what's called a supplemental needs trust or a special needs trust, and they can continue to get benefits, and the money is only used for things that are not available to them with their assistance money. So it helps their standard of living, their quality of life. Whoever you name as the trustee.
Well, I'm wondering how onerous it is and how good they are with money. I mean, is that a difficult thing to find someone who would be responsible? And it might also be, if you're an elderly person, then you don't want to pick someone who themselves is going to be dying within the next 2 years or so.
Yeah, Terry, that's an amazingly complex topic. Who should be the trustee? What should be the trustee? Maybe it shouldn't be a who. Maybe it should be a professional. What does it cost? What skills do they have? How much help are they going to need to buy with accountants and tax preparers and attorneys and investment advisors versus that package that's available through a professional trustee? There's all kinds of issues which we could spend the whole hour on just talking about.
I'm sure we could do a day-long seminar on
how you pick the right person to be the trustee. And we have a guide that we give individuals, because oftentimes people come in saying, I want Uncle Harry to be my trustee. Because, does Uncle Harry do this? Well, he's never done it before. Does he know what he's getting into? Well, you know, he's really good with, you know, gosh, he could, great with money. Okay, so I send Uncle Harry this 11-page guide about what the duties are, what the responsibilities are, what the liabilities are. And every so often, Uncle Harry says,
I'm going to pass.
Thanks.
Yeah.
And
can he designate, if he were the designated trustee, can he then assign to whom would take over?
Depends on the documents. In the documents I prepare, I always provide for the ability of a trustee to appoint either a co-trustee, bring somebody in that knows what they're doing to sit at their side, or a special trustee and say, hey, I want you to do the investments and I'll just make the distribution decisions. And so, yes, there is ability to, and of course we have successors in a well-planned estate, and if he really doesn't want to do it, he resigns and the next person that's named gets their chance to step up.
Let me go. There's going to be various levels, like a ladder of complexity that would be wise to have depending upon the size of your estate.
Right.
I guess the basic form is a simple will. A couple basic things. One, if people fill out, can they fill it out themselves? Can they just say, I want my 3 kids to have equal distribution of all my assets? And once they write that out, when does it become a legally recognized document? Does it have to be filed at the courthouse? What happens to that sheet of paper?
In Illinois, you can handwrite even, or fill out, use a form, fill out, do your own will. It has to have the requisite formalities to make it a will in Illinois. In some states, it's enough, it's called a holographic will. It's enough if it's in the handwriting of the testator, the person making it, and he signs it and dates it. That is not sufficient in Illinois. It has to have 2 witnesses who are not benefiting from the estate, who will testify that they saw the person sign it, they saw each other sign as witnesses, and that they believe the person to be of sound mind when signing it. And so if you don't follow those formalities, it's not going to be a valid will.
So an adult might have 2 siblings who aren't going to get anything. Say, I saw John sign the will to give his money to his kids.
Yes, it doesn't matter what their relation is, although we would counsel anyone that's trying to do this on their own not to have any related party at all be a witness, whether they're getting something specifically under the will or not. It's better to have family members out of that picture.
Well, how would you do it? I mean, you knock on your neighbor's door. Who would you get? Maybe just some friends, I guess.
Usually when we do have will signings in people's homes and they have their own witnesses, it will be neighbors, it will be friends. We kind of discourage the signing, but we also discourage people from trying to do this on their own. There are purveyors of these forms, LegalZoom being
Sure,
one that does a lot of advertising.
Well, can I interject before you get to
Sure.
that point? Because you're starting to answer a question I wanted to ask. At what point, based upon your assets, and we said, you know, well, at what point, based upon your assets, do you have to have, let's say, a simple will? Do you have to have, and what's after a simple will? You know, I don't know the stair step of complexity. At what point should you have a trust? And we might even say what a trust is or how it differs. I mean, just in a nutshell. Yeah. Again, we could spend an all-day seminar on these topics, so I'm we're just skipping across the stone here, across the lake. If someone says, you know, first of all, I think they tend to forget if they have life insurance that life insurance policy is going to be part of their estate, and so they may have more money coming in than they realize. They may feel like they only have their house and, you know, maybe they're worth $150,000 when they may be worth, you know, have $500,000 in life insurance policy.
Exactly. You know, the trust concept now is not so much the definitive guide to a complex estate versus not a complex estate because of this tax issue. The way to avoid estate taxes still is, if you have more than a $10 million estate, is to is to divide it equally between the spouses so they each have their own assets. And when the first spouse dies, theirs goes into a trust for the children, usually grandchildren, descendants, which the wife gets the income from during life, and then at their death, it goes wherever you say it goes. That uses the first spouse's exemption. And so that was the way we guarded against having an estate that skips the exemption at the first spouse, so it's all taxable to the second. Theirs is over the limit, and we pay a big estate tax. Now, with this potentially in Illinois $4 million that they can own together, it can all be in one spouse's name. They can give it all to the other, no trusts, and avoid any estate tax when the first spouse dies. Second spouse dies still with $4 million, gives it to the kids. Again, no estate tax, no trusts. So trusts now are not really the benchmark of whether it's a complex estate.
It's more it's a common thing to have then.
Now it depends on who the beneficiaries are, who you want to have it. Do they need a trust?
Well, and that was, let's just say, when we say a trust, is that basically just a way of holding funds with some strings attached? What do we say by trust, one? And two, we talked about the need maybe for, if not the need, maybe the one would want to have professional guidance on that kind of thing, professional administration. How costly is it so that if someone has an estate below $1 million, should they have professional help there, or is the cost of managing the trust become onerous?
Well, first of all, the last point first. The management of it in terms of professional versus having Uncle Harry do it is oftentimes a function of how long does it last. We can now do trusts in Illinois that potentially never end. They go from generation to generation, called generation skipping trusts. Have to have professional management at some level on that. Individuals are not going to survive. But you can have co-trustees. You can always have the individual beneficiary serving along with the professional. So sometimes it's the length of the trust. Sometimes it's the assets in the trust. If you have a lot of rental real estate that's going to be owned by the trust and has to be managed and repaired and taxes paid and leased out, you probably don't want to tie up an individual because they could spend their entire, in fact, I had one case where the individual was spending his entire life administering this trust. He could not work outside of his employment as trustee. So again, professional probably more apropos. Cost is all over the board. You can go to some banks, particularly in this area, rural banks that have relatively low fees, maybe 7 basis points, 7/10 of 1% of the assets in the trust per year. You can have some of the larger city banks.
Which would be about $700 for a $100,000 asset.
Yep. 70,000 would be 700 of.
Well, 1% would be $1,000.
Yeah.
For 7/10 would be $700 on $100,000. I mean, just to give people some idea what we're
good idea. About. But you can go up to 2%, even maybe a little over 2% on some trust companies. Don't want to name names, but some of the larger city trust companies and some of the larger chain banks. But there's all kinds of hybrid fees, and they can be pretty flexible.
So one can obviously just negotiate that kind of thing.
In many cases, it's negotiable.
If someone sets up Lawyer Bob as the trustee and I'm the co-trustee, I didn't pick Lawyer Bob. If I have a bad relationship with him, can I change him? Or am I stuck with him?
If Lawyer Bob is the lawyer for the XYZ Trust Company, no, you can't do too much about that. You could, in many of my documents, all of them actually, we make a provision for removing a trustee, so that if the trustee is not investing as you have been comfortable with, directed them to within your risk tolerances, all of the kinds of criteria that you've set up, if they are not making distributions according to the terms of the trust, if they're uncooperative, if they're not nice to deal with, whatever the reason, they can be removed and another trustee can be put in. And so if the lawyer serving that trust turns out to be a problem, that could be a reason to remove them.
And hopefully other people do that. I mean, because obviously the other trustee anything could happen. He might have a stroke and be incapacitated, and you'd want to have some flexibility on that. Do you know what is the average size of an estate in Illinois?
No, I don't.
I would guess most people have an estate probably below $1 million at the time
I'm
of
sure
death.
that's accurate.
So for those people, let's just say, you know, the average family, what would they do if they're listening to this and saying, okay, I mean, there's a lot of complexity here, but, you know, I have an estate that might be worth $500,000 to $600,000, depending upon the value of the real estate and stuff, you know, their home. What should they be doing if they haven't done any planning thus far?
Well, they still need a will for the reasons I mentioned, and maybe a few more I could go into, but they can direct who they want to manage it and the estate part of it. Just, we're not going to do any long-term trusts. We don't need to safeguard any assets for minors. We can distribute it to adult children when we die and they're all fine, upstanding citizens.
If that's the case.
Yeah. But, you know, those are all the kinds of factors where they may need to do some other kind of planning. We need to put someone's share into a trust and not give it to them, have someone else manage it for them, or cut them out completely in some extreme situations. But we're talking about the average estate, small enough we can just distribute it. They may want to make specific gifts. They may have a church, a charity, a relative, a friend that they want to give some money to at their death, can specify that in the will. They may have personal property that is very close to their heart that they want to make sure that the daughter has a certain piece of jewelry and the son has a particular piece of furniture that's come down through the family. You can specify the things in the will.
Individual choices that would vary by family, but just as far as a document, if they just fill out even a simple form, a simple will, does that avoid probate? Going to probate if you have a simple will that says, you know, maybe it's just my wife and my elder son, and whatever you say in the will. What's the process then after you die if you have at least that simple will?
Okay, well, avoiding probate, another interesting subject. If you have $100,000 and no real estate, $100,000 or less, and no real estate, total assets, there's a thing called a small estate affidavit that allows you to not have to probate the estate. But if you have $105,000 in a savings account, the bank will not release it to whoever you said gets it in your will unless you probate that will. And
probate means going to court.
Means going to court, having your person you've named as the executor appointed by the court with authority issued by the circuit clerk in the form of letters of office that can then go to the bank with the death certificate and get the $105,000 and administer it under the terms of the will.
Just on the will itself, you have two people, two friends who aren't going to get anything, witness the signing, and then what do you do with that piece of paper?
During your lifetime, you keep that paper.
I mean, do you have to file it?
No, because it can be changed tomorrow.
So you could just stick it in some safe place?
You do not file it because it can be changed. It may be changed a dozen times before you die.
Right.
So you put it in a safe place, a fireproof place, and let people know that you have it and where it is, and give them access to it in case there's a need to find that at some point in time.
And then when you die, they take that piece of paper, and then what happens to that piece of paper?
Well, as I said, it has to be filed, even if you've got no intention of probating it, and then nothing happens. There's no fee. It just sits in the county archive. Yes, exactly. Sits in their archives.
Certificate along
Nope.
with
No, just file it. And if you do nothing with it, probate-wise, it just sits there. But if you do need to probate the will, then when you file your petition, that will comes out of storage at the county building, and the court admits it into probate.
Do you know what percentage of people in the state of Illinois approximately die without any will at all?
I've heard percentages as high as 70+%.
And am I correct in saying that that costs them, their estate, a lot of money that they would otherwise been able to hold on to? Or does that not apply anymore under the current law?
Well, again, I'm not sure how much money it costs, because there's no tax difference between having a small estate that's probated and one that isn't.
Just from a processing standpoint, going through they would have to go through probate then.
Yeah, the only out-of-pocket cost that I know would be different in the probate process is, well, it may not be, but potentially is this, the bond and the guarantors, the sureties on the bond. That might have to be an insurance company.
Would you have to have a lawyer?
It costs thousands of dollars. You're going to probably have a lawyer either way.
Okay.
And the process itself is not any more arduous or longer under the administration as it is. You just don't have any control as the person passing the property to the next generation over how that process is going to be handled and who gets your property.
We talked a little bit without pointing fingers at any one, but there are the legal forms you can get online. And obviously they're relatively cheap. I think something like $60 or something like that,
right.
Which is obviously a lot less than working with an attorney. But I don't know if you would argue that you're going to pay a lot more than that in the long run. Is that suitable for most people, or?
Well, just generally speaking, most of those documents are drafted to be administered in any state. I mean, they oftentimes are very generic. Sometimes they are not drafted well enough to be admitted into probate. Sometimes they are not executed properly so that they can't be admitted, in which case you've lost whatever you put into the project, and you're back to where you started without doing anything.
But is that because I mean, again, it seems like a simple will would just be to say, here's what we need to have, and you attach a document listing whatever properties you have and how it's going to be assigned, and then you...
Yeah, you don't have to attach anything saying what you have, because again, that changes over time. Generally, it's you can make specific bequests. Right. You know, I want the family farm to go to son A because he's farming it, and I want everything else to go to son B because he's not. But you don't, unless it's a specific bequest of something, we don't mention assets, because that could change drastically up, down, or in any direction.
But the point is, as far as when you say that they didn't necessarily do it right, what would they not do right? That they wouldn't have two people sign it?
Well, there's oftentimes the failure to have two people sign it, or the wrong two people sign it that are interested parties, or they mailed it around to get it signed.
But typically, if you get then two friends or two people who are not going to be well, you said not even family members, so two people that maybe you would know that can witness it.
Yeah, focusing on the execution thing is probably one of the biggest problems, but oftentimes the language in the form itself is not what the person needs because of their situation. You know, they have a disabled child, and they should be setting up.
But I'm just talking on the legality of it, not whether it's appropriate to their estate. Just on the legality standpoint, it's not that complex. And I'm getting to, if, as you mentioned, there's a high percentage of people that don't have any document at all prepared. So under the old saying, don't let the perfect be the enemy of the good, they should do at least something, and it's not that complex. And then they might want to say, depending upon their estate, maybe we want to set up a trust. And I would say a trust then can have not only the distribution of assets, but can't they also then put in that trust maybe if they're elderly, if, you know, how much care they want to have, if it should be extreme measures taken to save their life or not?
Mm-hmm. Well, that's a power of attorney, which is another separate document which everyone should have. So I'll just comment on that briefly in a minute. That doesn't go in the will. In fact, I try to keep things like I want to be cremated out of the will. I unfortunately had a situation where someone came in and opened the will and the family was there, and they had just, you know, had the funeral a couple of days ago, and I opened the will and it says, I wanted to be cremated, and they were now interred. So it's better not to put those things in a will. It's better to put them in separate directions that everyone knows about, or in a power of attorney for health care.
And what does it mean to have power of attorney?
It
doesn't necessarily mean that you have to be an attorney.
No. But we use the term attorney in fact as an agent that's appointed by the person that can act in their stead.
In layman's terms, we might say we appoint someone to be the decision maker.
Well, yeah, the agent, the person who, under these documents, has every right that you do if you give it to them in the document, and I'll talk about that just a little bit, but to perform. And the healthcare one is the one where you can direct the pulling of the plug under certain circumstances. You can direct organ donation or none under however you want to do it, and you can give special directions to. I know certain religions have certain customs that they need to follow. You can make sure that those are going to be followed by the caregivers. And on the property side, the agent has the right to manage your assets, collect any income that's coming to you, pay your bills, file your tax returns, and keep things insured, everything that you can do. There are some things that agents can't do.
Let me ask a legal question. If I assign Joe to be my power of attorney, and he goes and files some of the forms that you just mentioned,
Yeah.
How does the government know that Joe has the power of attorney? Is there some document to prove that in my lifetime I assigned Joe? Because otherwise, it seems to me you could be opening up to all kinds of fraud that just any guy could say, I have the power of attorney and I sold his house and his automobile.
Well, yeah, that whole process has evolved within the last, I don't know, 20-some years into a pretty much standardized format. In Illinois, we have what's called the short form power of attorney for health care and property. The forms are actually, if you go to the statute, you can print out what the form looks like.
Can that be a family member, power of attorney?
Absolutely.
And so, as far as what people should do to take away from this interview, some of the action items, they ought to have at least a simple will. Mm-hmm. They may want to meet with an attorney and a planner, a estate planner, and kind of say, you know, do you need a simple will or do you need a trust? But they should also right away have power of attorney because they could have a stroke and need care and maybe wouldn't be able to act in their own behest while they're alive.
Absolutely. The most, in many cases more important than the will, in the sense that no one is going to take over this property management without a formal guardianship proceeding, which does take time, which is fairly expensive, requires at least 2 attorneys in the process, one to create the guardianship and one appointed by the court as a guardian ad litem to report back to the court and say this is in the best interest for this person because they can't take care of themselves anymore.
And that all expense, the 2 attorneys, which as you say is expensive, can be avoided just by having a power of attorney.
Exactly. And you can give that power of attorney more powers than a guardian would normally have if you want them to have. One of the major ones, especially for larger estates that we've dealt with, is the power to make gifts. You can't even give a $100 Christmas gift to your son without authority in the power of attorney to make gifts. You can have them, one of the things we've started doing is make sure that this agent has access to your digital assets. We're finding that so many things are password protected, are not owned because of the service agreements that people sign when they create a Facebook account or whatever. They don't have any rights to those platforms. The platform is owned by the provider, and without the person who created the password and the password itself and their username and all of the things that you need to access it, the executor, or in this case the agent under the power of attorney, can't even access it.
You had mentioned off camera some time ago to me that there's a famous author who apparently wrote a book digitally and no one can access it after their death.
Leonard Bernstein, the famous
that's right.
composer, musician, author. We believe his memoir was in an electronic medium. He died in 1990 and was password protected, and it still has never been opened by the family to whatever personal loss and financial loss that might be to them.
Well, and one can imagine. I mean, no, that's not going to impact most people, but it is wise on the other hand. It's a good illustration of a whole new form of assets when we talk about digital assets that we didn't even have to think about 25 years ago.
Yeah, people have online accounts. There's money in some of these. There's just all kinds of issues.
And I meant to ask you, this might be a good one. Just as we're sitting here videotaping this, it seems like a piece of paper is so 19th century, you know, that can we have wills these days that are just videotaped, or do we still need the piece of paper?
You still need the piece of paper.
I guess because you can't file a videotape. Actually, you could digitally.
You could file it digitally.
Is it wise to have a statement and that is videotaped of your intentions, and is that recognized by the court?
Sometimes we insist that the will signing and execution be videotaped because we're anticipating a lawsuit by an
aggrieved party.
And they are going to claim that this person was of unsound mind or was being coerced, unduly influenced to do this, and so we take great pains during the process to debunk all of those potential theories. And so yes, we do videotape some of them. In a normal situation, it would be an expense that could be avoided. You do have to have, if you do that, you then, if it's going to be evidence in a trial, you have to preserve the chain of custody of this videotape, or it's useless when you get down the road 10, 15, 20, 40 years later when the death has occurred, the lawsuit is commenced, and we have to bring this videotape or CD or whatever medium out of storage and prove that it is the valid tape. So, but yeah, digital assets, so many of them now don't have paper, and all of our laws, virtually all of our laws involving assets are paper-oriented, paper-focused, and that's going to change. And as that changes, the protection of digital assets, and maybe even we will make provision for having wills and trusts be done digitally rather than on paper. But that's for another day.
And lastly, if somebody says, I would like to proceed, you convinced me, but I want to have an attorney guide me. Of course, this is going to be seen all over the state. What's the best way to find someone who's a competent attorney to handle these issues? Not all attorneys are created equal.
It is true that attorneys, the general practitioner, except in the very, very, very small community, doesn't exist anymore. Most of us recognize that we can't do everything. One of the sources potentially, and I know there's a good referral service that's the Illinois State Bar Association maintains, where they can give names of people that have held themselves out to them as being estate planners. There are organizations that a person can belong to in the estate planning world. It's called the American College of Trust and Estate Planning Council. ATTY is an acronym. A roster of their people. We have to be elected to this. You can't just say, I want to be a member.
So if we just find someone maybe who specializes in estate planning and then ask for their credentials and their professional credentials.
Well, there's publications too, Leading Lawyers Magazine, Super Lawyers.
And these are all available online.
You can go online. They break these people that have been peer-reviewed, peer-selected down by categories. Find one that's local to you, and you'll be way ahead of the game of just flipping open the phone book. But even there's yellow pages, and some people have at least pre-selected themselves as holding themselves out with that, which is better than just trying to pick.
Well, and lastly, and before we close out, the other thing I think that the thing for people to, no one wants to think of their own death, and it's probably emotionally unsettling to have to deal with this, which is why people put it off. Yeah. But aside from the financial aspects, I would think it's also, if you don't have all your information put together, here's my bank accounts, here's the passwords to my bank accounts, here's my credit card numbers. If that's not organized, then whoever becomes the person that has to administer the estate, and it might be a sister or some kind of a family member, it just makes their life probably hell trying to track down all these assets, with the very real possibility that they're not going to find your assets, and thousands of dollars potentially could be lost because no one knows where you've put your money.
That's absolutely true. Many years ago, I was an executor for an estate, and at 10:30 at night, while I was going through drawer after drawer of receipts, this person, the decedent, kept everything, and thinking I had just uncovered a drawer that I could dump into the trash bag, I unfolded a piece of paper that was 500 shares of General Motors stock. And so I realized I had to look in that house at every piece of paper before I'd throw it away. An amazingly long, especially for an outsider. This was a client of mine that asked me to be the executor, and I don't normally do that, but they're also a friend, and I had a co-executor. So don't do that to your executor. Be organized. If you have a computer, it's a lot easier now to start a Excel spreadsheet or whatever. Tell them who your investment advisors are, who the insurance agent is, where the safe deposit box key is kept. passwords for, and I know you're not supposed to write down passwords, but if you...
Well, we look at the Leonard Bernstein thing. If you don't do that, then it's lost.
Yeah, or tell them where to find it, or give them a password to an account that you set up, that you put your passwords in, and
could you not
update
just put the old, put it in, print out your Excel spreadsheet and put it in open, say open on the event of my death?
Sure.
And maybe that's in your safety deposit box, so no one's just going to be picking that up.
And update it. I mean, if you do one, and the way things change and the new investments you come up with, and the you have to just keep updating it. But that is so helpful to the person. It saves so much time and effort, and as you say, can sometimes result in all of the assets being found as opposed to some of them never being found. And you can go on Dan Rutherford's website and find all kinds of instances where people have bank accounts that the bank has turned over to them and that no one ever found, apparently, in some cases at a death. So very important to be organized.
All right, well, Jim Lestikow, we went a little longer than I anticipated, but we appreciate you taking the time to explain this to us.
I'm very happy to do so. Thank you.
You're watching the Illinois Channel, an independent nonprofit corporation formed to provide gavel-to-gavel coverage of Illinois state government and other public affairs events taking place across Illinois.